Hello, I'm Dominic Walker, JMW's Inside Man. My guest today is Jessica Stanway. Jessica is a solicitor within JMW's commercial litigation department and specialises in property litigation. Now, Jessica, there's been an announcement by the government in relation to the removal of cladding. Can you tell me and just give us an idea of what's happened, please?
Hi, Dom. So yesterday, Michael Gove set out his new plans to tackle the building safety crisis. We've seen various attempts before this, but I think the general consensus is that this announcement seems more significant than the others, and there's a sort of number of updates to be aware of. So the announcement includes a number of wide-reaching proposals, at the heart of which is the government's open position that it's the developers, contractors, and manufacturers that are responsible for the problem, and that leaseholders shouldn't be bearing the brunt. So the government's promising a new £4 billion fund for cladding remediation costs for buildings between 11 and 18 metres. So you might recall that buildings under 18.5 metres were not previously included in any of the proposed funding plans. So this development replaces the previous idea of interest-free loans that were to be offered to the leaseholders and wasn't a popular idea at all. I do think, however, it's important to be cautious as there's no new money being offered by the government. Instead, they're sort of relying on developers and manufacturers to raise these funds. And it's not known yet how they intend to compel them to fund the works. But the government did threaten developers with the potential of, say, new taxes or new legislation that will come into place in order to force them to contribute. Another key development is the commitment to extend the retrospective limitation period under the Defective Premises Act from 6 years to 30, which could potentially capture a number of new claims against developers, which were previously statute barred. But I would highlight that these announcements relate only to cladding remediation work and don't include non-cladding costs. However, Michael Gove did suggest yesterday in response to Lisa Nandy that leaseholders will not be responsible for these costs as well. There was a welcome proposal to almost double the Waking Watch Fund by providing a further 27 million, which will go towards funding alarms and other measures. And there's also suggestion that fire risk assessors are to be indemnified, which will hopefully assist in relieving the backlog of buildings which are still waiting to be assessed, and will hopefully help those leaseholders who are trapped by the can't remortgage, can't buy problem. And in addition, the government is trying to reintroduce confidence in the lending market. It's withdrawing its current consolidated advice note, which is the one which requires the use of EWS1 forms, and it's replacing it with new guidance on assessing fire risk, which is hopefully going to be more proportionate. And finally, there was also recognition of specific challenges which are faced by leaseholders, and the government has committed to protecting leaseholders from eviction or forfeiture over fire safety costs. And it's also committed to allowing leaseholders of shared ownership flats to sublet their properties in order to allow them to move. But how these proposals are going to work, bearing in mind existing lease provisions, is uncertain.
So, Jessica, what does this all mean for the landlords and the management companies, and conversely, for the leaseholders, i.e. the people who actually live in these properties?
I wish I could say exactly, Dom, but it's not entirely clear at the moment what these proposals are going to mean for fire safety and remediation works in the immediate future, or how these proposals really work with the existing leasehold legislation. There's obviously a significant shift towards protecting leaseholders. However, I think it's fair to say at the moment it's not known how these are going to play out or what they're going to achieve. We'd expect that there's going to be a lot of uncertainty over the next few weeks and months for all parties. And in addition, I think there's also going to be scope for landlords and management companies to revisit previous advice that they were given in respect of limitation in particular, as it may be the case that these claims are no longer statute barred.
And it sounds to me then that bespoke advice is required, and it's almost like a case-by-case basis. Are you able to help with that, Jessica?
Yeah, so I think the important thing is that if you're unsure at all, then you seek advice, whether it sort of relates to the legal position for the works themselves, or liability, or even ancillary issues such as potential service charge recovery or Section 20 issues, or even dispensation applications. But our property litigation team is constantly keeping up to date with these changes. And we also sort of understand the practicalities of property management and development in all sorts of blocks. So our advice can always be tailored.
Excellent. Thank you very much for your time, Jessica, and your insight. And if you'd like to contact Jessica, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.